first case of the morning, I believe, is State versus Walton Kirkendoll. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes.
Very good, I'll make a note of that. I'm keeping the time up here. I'll try to let you know when you're about 1 minute left of your time. I'll give you a warning at that point when you get to there. Arguments are being recorded. Make sure when you come up to the podium, stay behind the podium, because we're video recording you as well, and we'll lose you if you go moving around. And you speak loud enough so the recording can pick you up. Don't use the name of any child, victim, or minor when you're presenting your argument. Please use initials or some other name like child or victim or something that's what we're referring to. With that, the judge has read your brief and are ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court, I'm Attorney John Chapman, representing Mr. Kirkendoll and standing in for Attorney Wesley Johnston. Your Honor, the brief sets forth all of the facts of this case, and the facts are very straightforward, as well as the issue is very narrow. So I don't know that we need to get too far into the details of that. However, the fact is that my client, Mr. Kirkendoll, he was charged with a crime. He entered a plea of guilty to that crime pursuant to a plea negotiation, and then later wanted to withdraw his plea, claiming ineffective assistance of counsel. During his plea, he did go through the traditional plea colloquy where he answered the judge's questions. He acknowledged that he was satisfied with the performance of his attorney, that he understood the consequences of what he was doing, and the judge determined that he had made a knowing and intelligent plea with the assistance of counsel. And anyone who's been through those, they are all very much the same. Judges do them in every court, and it's very rote in tradition and just set in stone as to what's said and by both parties. Obviously, if someone were to answer that they were being coerced, or were to answer that they were not satisfied with the advice of counsel, the plea would not be accepted. I think the state would, in their brief, argue that that should be the end of it. They've acknowledged that their counsel was good. They've acknowledged that they understand what they're doing, and that should be the end of the inquiry. However, the courts have acknowledged that we must go a little bit further than that when the claim is ineffective assistance of counsel, and that's why they want to withdraw their plea. Certainly, the presumption goes with what they stated in court. The presumption is certainly going to be against my client that, once he's gone on the record stating that he was satisfied, that will be the end of it. The courts have required that there be three elements that, in order to satisfy the question of whether or not there was ineffective assistance of counsel with regards to a plea. There are two elements. That the trial counsel's performance was somehow deficient, and that there was a reasonable probability that but for that deficiency, the defendant would have not entered his plea. In this particular case, we have what I would consider to be a spectrum of the scope of the representation, a sliding spectrum. We're supposed to give our clients advice, and sometimes that advice goes into this realm of influence, and then we must guard against that influence becoming coercive influence. In this particular case, we have, as required by the courts, more than just a defendant's assertion that they were somehow coerced or prejudiced by the conduct of their attorney. We actually have the ability to look into what was said between the defendant and his attorney. We have letters from the defendant to his attorney. We have a letter from the attorney to his client. And that gives us an idea of what was being said to him and what was being done with respect to preparation for trial, and whether or not his conduct was deficient. In this case, the defendant was someone who maintained his innocence from the outset of the case, pled not guilty, worked diligently with his attorney in person and by these correspondence to lay out different theories as to how to defend the case. He provided his attorney with the names of witnesses that could be subpoenaed to testify on his behalf, what he believed would be his actual innocence in this case. There was a great deal of back and forth between the attorney and the client on this. Despite that, the attorney then turns around on the eve of trial and says, you know, I have fully prepared the case. And yet the record reflects that no witnesses were subpoenaed for the trial, which was due to start, I believe, either that day or the next day.
Do we know from the record if the attorney spoke to those witnesses?
We do not, but what we do have
We
is
know if they were, does this court require them to be disclosed as witnesses prior to trial?
I'm sorry, could you repeat your question?
Does the court require them to be disclosed as witnesses somehow in discovery or otherwise prior to trial? In other words, I appreciate they weren't subpoenaed, but
They would
were they
certainly,
disclosed as folks who may be witnesses that may have been showing up voluntarily?
well, they can show up voluntarily, but they would still have to be disclosed to the.
And I don't know if that was, do we know from the record if that was done? That's what I'm asking.
I don't believe that that was done. The attorney states that everything had been done in preparation for the case. The defendant states that he later learned that no one was subpoenaed and that no one was spoken to. Certainly we know that.
But an affidavit indicates that he's aware that they weren't spoken to.
I believe that that's the case. I would have to.
I understand the certain, that does seem to go ahead.
So I think that when you look at the conduct and whether it was deficient, I believe you have a bookend of statements by the defense counsel that establish that. The first is him telling his client on the eve of trial that everything has been prepared, when the record reflects that at least no one had been subpoenaed. We don't know what other preparations may have been done, but he's not just saying, I have prepared the case. He's saying he prepared the case in the manner in which they discussed, which would presumably include the subpoenaing of witnesses to testify on the defendant's behalf. So it at least raises the possibility that the attorney had not prepared or subpoenaed those witnesses and that he's not being forthcoming with his client about that. You then get into the other statements that the attorney was making to his client that day, where he, obviously, as defense attorneys, we are required to be very candid with our clients as to what their prospects are. We have to tell them what the potential penalties are if they go to trial. We have to be able to tell them, what we feel is going to be the evidence in their favor and how we feel the case might go. A lot of clients will ask us things like, well, what's the percentage chance, or I'm going to get convicted, or what do you think we should do? We have to guard against allowing our own opinions to leak too much into that. We have to give them our frank assessment of the case, but ultimately leave final decisions to them. And I think that this attorney, when he goes further and tells him that it doesn't matter if you're innocent or not, you're going to get convicted, I think that crosses the line from influence and advice into coercion. When you're telling someone in this circumstance that you're going to get convicted, that raises the specter in their minds that they're not going to get a fair trial. How can I proceed if I
Counsel, can you tell me where I will find that in the record that the attorney said you were going to get convicted?
It's in his letter that he sent, I believe it was the November 30th letter, where I don't believe he says he's going to get convicted, but he does say that it doesn't matter if you were innocent or not, or words to those effect. And obviously we always tell our clients, if you go to trial, you're potentially going to get this sentence. Based on my experience, here's what it's likely to be if you're convicted, and if you take the deal, here's what the offer is that's on the table.
And counsel, can we talk about that for a minute? So in this instance, am I correct in that the attorney explained that he had specific concerns about, the strength of the case? He say that he could potentially receive up to 35 years?
He did say that, and
the deal that was negotiated was a recommendation of 5 years.
I believe that's correct. Then I believe that's what he ultimately received as well. The problem being is that while laying those things out, if you were then creating this era of, well, you have to take this today or you're going to get 35 years, that it doesn't matter if you're innocent or not, that crosses the line and takes it further from just giving them the advice as to what might happen, and creates the certainty of what will happen. And that is a coercive influence.
Wasn't his opinion, or his advice, wasn't it preceded by, it's my strongest professional suggestion?
You have about a minute left, Mr. Chairman.
Professional and personal opinion. He actually says that in there, that it is professional and his personal opinion. And personal opinion stating, what he would do under I have clients ask me all the time, what would you do under these circumstances? And I am not supposed to answer that question because it's not me. I can't judge their liberty for them. I have to lay out their options, give them my best advice, and let them make the decision. But I can't imagine what would happen if I had talked to my client before court today and said, you should drop your appeal because you're going to lose. That would presume in his mind that he's not going to get a fair hearing from this court. It would certainly presume in his mind in those circumstances on the eve of trial, right before his plea, if he hears from his lawyer, doesn't matter if you're innocent or not, that would certainly give rise to his fear that he was not going to receive a fair trial, that he had no chance of winning, and that therefore he should take this deal that's on the table or else he's going to get 35 years. That's inherently coercive.
Counsel, did he speak in terms of this is going to happen or that this is a risk?
I believe he was much more certain than that. And while I think he tried to couch, at least in his letter, to try and couch things as things being a risk, certainly I believe that once he crossed that line into expressing his personal opinion and that there couldn't be, and at least hinting that there couldn't be a fair trial and putting that into his client's mind, that certainly played an influence on his client's decision, who could have, if he wasn't satisfied or if he felt that things hadn't been properly prepared, asked for another attorney or asked for a continuance or had any other option. Telling him that it didn't matter if he was innocent or not, raising the specter of not getting a fair trial, that certainly, if the attorney believed that, he had other options. He could have filed a motion to change the venue or change the judge or withdraw his counsel and have someone else get appointed. But instead he's telling his client, you have to take this deal, it doesn't matter if you're innocent, you're looking at 35 years, and that's a coercive influence. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. Lindsay Toprak of the Lorain County Prosecutor's Office on behalf of the state. This court must affirm the lower court's judgment because the trial court properly exercised its discretion when it denied Kirkendoll's post-sentence motion to withdraw his guilty plea, absent the showing of a manifest injustice. Walton Kirkendoll's post-sentence motion to withdraw his guilty plea was based on a claim, as we've heard, that trial counsel was ineffective and coerced him into entering his guilty plea. As counsel correctly laid out, he correctly laid out the burden to show that counsel is ineffective. And he claims that the 3 letters that were exchanged between himself and trial counsel demonstrate that his plea was not knowingly, intelligently, and voluntarily made. And as we've heard, though, he makes no claim that the trial court did not fully comply with Criminal 11 in the plea colloquy, because Kirkendoll acknowledged that he understood the nature of the crimes to which he was pleading. He was advised of the potential penalties and informed of the rights he would be surrendering by entering into his plea.
Counsel, I guess what they're zeroing in on, though, here is one of the big factors. Wouldn't have been covered in the plea colloquy, and that is, yes, he can say I was satisfied with, my counsel's representation, but how was he to know that when counsel sent him the letter that said, I prepared according to your letter, that did not include subpoenaing, and maybe even not disclosing the witnesses that he had asked to be contacted?
How was the trial court supposed?
No, I'm saying, you're talking about the plea colloquy, okay? And ordinarily, that might be dispositive. But here, you have the client saying, I wouldn't have pled if I had known he hadn't contacted these witnesses, because he said he prepared for trial, so if he's prepared for trial according to what the defendant asked him to do, he would have talked to the witnesses, at least talked to them, now we may not know, but talk to the witnesses for his assessment of the strength of a case. How can you assign the strength of a case an evaluation without talking to witnesses that the defendant has requested?
And I think that goes to Judge Stevenson's point. Kirkendoll concedes in his brief that the record is silent on Attorney Rich's preparations. There's no indication whether Attorney Rich did in fact speak to the witnesses or not. The record does show that the witnesses were not subpoenaed, but it does not show whether he in fact discussed their testimony with the witnesses.
Either, though, right?
I'm not clear on that.
There's nothing on the record in the Lorain County case that would tell us here are the defendant's witnesses, I take it, is what you're telling me.
I believe that discovery would show that, the filing of discovery. But an attorney is presumed competent under the ineffective assistance of counsel standard, and they're also entitled to rely on their trial strategies. And here, if Attorney Rich had discussed the matter with the witnesses and determined that calling those witnesses would not have been within sound trial strategy, I think that's entitled to deference. And here he had he indicated in his letter that he had reviewed a videotape of Kirkendoll's voluntary interview with the Elyria Police Department, and that's one of the factors that played into his assessment of the strength of the state's case. And in doing that, he came to the conclusion that the state's case was strong, and that is one of the factors that led him to advise in his best professional judgment that Kirkendoll should strongly consider taking the plea.
Is this something where the trial court should have held a hearing?
I don't think that the trial court's not required to hold a
I
hearing.
know it's not required, but is this something that the trial court maybe should have held a hearing on?
I think that if the face of the documents do not show that the trial court needed to hold a hearing, I don't think we can, it's an abuse of discretion standard. And whether the trial court needed to hold a hearing is based on the face of the evidence before it.
And I was going to say, I'm sorry for interrupting, but there's such limited time, so I apologize. I'm not doing it on purpose to be rude to you. But the trial court here really didn't explain how he used his discretion either. I mean, if it's just a one-liner, it's denied.
Correct.
So
I
what are we to take
understand
from that?
I also don't think they have to state findings of fact for their reasons, but that does give I understand that gives the appellate court a limited record to review. I would state in addition that Attorney Rich did outline the substantial sentence that, we've gone through this, but the substantial sentence that Kirkendoll was facing, and he was facing multiple firearm specifications if he was convicted, including an RVO specification, and the state agreed to dismiss some of those specifications and or amend those specifications. The judge did run his sentence concurrent to other charges, and courts have said that when there's amendments and significant benefits from a plea, that weighs against counsel being ineffective because they've gained favorable outcomes for their clients. Attorneys are permitted to give frank assessments of their case, of a client's case, to their client. That's not being threatening or ineffective or coercive. That's giving sound legal advice and professional judgments. Here, the fact that Attorney Rich did not threaten or coerce, I think we have to go back to the plea, because the fact that Attorney Rich did not threaten or coerce Kirkendoll is supported by the record of the plea. At the time of his plea, Kirkendoll was questioned as to whether any threats or coercions were made towards him, and he said no. He was asked if he had anything else if he had any questions trial court, and he said no. He was asked if he was pleased with the services of his trial counsel, and he said yes. So for those reasons, I would ask that the decision of the trial court be affirmed, and thank you.
Thank you.
You've about 3.5 minutes left, Mr. Chapman, for a moment.
Mr. Kirkendoll would not have pled if he had known that his witnesses had not been subpoenaed. The simple fact is that the letters reflect a great deal of emphasis on his part in preparation for this case. He provided the names of witnesses he felt that could prove his actual innocence, and he provided the contact information to his attorney, and his attorney advised him that his case had been prepared according to his wishes, not according to the attorney's wishes, which sometimes differ. I've had to tell clients that, you know, their witnesses are not going to be good witnesses for them, or that their theory of the case is, you know, not anything matching reality. But in this case, the attorney said he was ready to go, and that the case.
So the defendant in this case was sitting there the day of trial. I take it you're telling me he assumed the witnesses were subpoenaed.
He would assume that his case was prepared because that's what his.
Well, I'm not disputing that, I just want to make sure, that's why I understand. So he thought when I made the decision about pleading, I have 3 witnesses over here that are going to testify for me. He made the decision thinking that was true, and now he found out it's not true.
And again, we're not relying on just his own statements. An objective reading of his letters and the letter from his attorney to him would suggest that that is exactly the case. That he
And I'm not saying you're wrong, it just seems to me that, as I understand that, that's what defendant would have been thinking the day of trial when he pledged, I have these 3 witnesses out here and they're going to be there for me to testify. He found out later that wasn't true, but at trial he thought that was true.
That's correct.
Okay.
And there's nothing in the record that reflects that his attorney ever led him to any other conclusion. The other side of this is that he would not have pled if he had been told that his innocence, whether or not he was innocent, a person's innocence didn't matter. Again, you know, I do a lot of plea negotiations. I have a lot of defense cases. I can't imagine that I wouldn't be able to get every one of my clients to plead guilty to whatever was being offered if I told them it doesn't matter whether you're innocent or not. It doesn't matter what your evidence, you know, it doesn't matter what your evidence is. Doesn't matter. To be able to tell a client that, you know, that their side of the case doesn't matter, or the truth of the case doesn't matter, would allow me to get any client to plead to any deal that's offered. Because why would they have a trial? Why would you risk going to court if you know that your innocence doesn't matter? And certainly, I think any defense attorney would be able to stand up here and tell you that they've had cases where clients have, where we've been personally certain that it was going to be a conviction, and we've gone to trial and it's been an acquittal, because the truth is we don't know what's going to happen with a jury. Anything can really happen with a jury. You can get, you know, good cases can be found, you know, guilty, and bad cases can be found not guilty. Everybody's had that experience. So to be able to have an attorney putting this in such certain terms and such in what we would argue are coercive influencing terms, as your innocence doesn't matter, certainly weighs upon the decision that he made. And I think that at the very least, there should have been a hearing in this matter, but certainly his conduct, the conduct of the attorney in this case, crosses the line on that spectrum from advice to influence to
In your
coercion.
rebuttal time is over, if you could briefly conclude, Ms. Chapman.
I think I have nothing further at this point. I think that sums everything up. Thank you.
Thank you. The court will take the matter under advisement and let the decision in due course. With that decision